A very warm afternoon to one and all present here. I, Riya Chakravarti, practicing advocate at the High Court of Tripura, would be anchoring this third session. Now I request our speaker, Professor Dr. Mohan Gopal, former Director, National Judicial Academy, and Chairperson, Mr. Justice S.G. Chattopadhyay, to grace the dais. Now I request our High Court staff to felicitate our speaker, Dr. Mohan Gopal, and Chairperson, Mr. Justice S.G. Chattopadhyay, Judge, High Court of Tripura. We really feel honored to have with us Dr. Mohan Gopal. Professor Dr. Mohan Gopal, a leading voice on judicial reform and justice in India, has been the head of the National Judicial Academy of the Supreme Court of India from 2006 to 2011. As the director of the National Judicial Academy, with his efforts and vision, he brought in vibrancy in legal education for judges. He standardized the approach to such legal education and revitalized state judicial academies. A former Vice Chancellor of the National Law School of India, Bangalore, Professor Gopal is also a former member of various national regulatory bodies. His work focuses on the role of law in democratizing social orders as well as on the internal democratization of legal and judicial systems. Today, Sir is going to speak on the topic, constitutional vision of justice and the role of judges. Man is not made for law, but the law is for man. Our constitution, being our parent law, has been made with the primary vision of inseminating justice. It has done so by granting fundamental rights to its citizens, which can be enforced through writ jurisdiction of the Supreme Court and High Courts under Articles 32 and 226. Similarly, the inclusion of directive principles of state policy aims at establishing social and economic justice through a welfare state. The Constitution of India enjoins the state to secure social, economic, and political justice to all its citizens. Our Constitution has successfully aimed at dispensing justice to all belonging different economic stratas by incorporating Article 39A, which intends to provide free legal aid to the economically challenged. Justice is a concept of rightness and fairness, emancipated through individuals, that is, judges. It is the judges who interpret the law and deliver justice for the greater good. The Constitution of India speaks of social, political, and economic justice for all the citizens. This manifests a grand vision of the nation of bringing about peaceful social revolution through constitutional means. The judges are in a pivotal position and therefore owe a great duty to fulfill this dream and vision of the nation. I shall now request the chairperson, Mr. Justice S.G. Chattopadhyay, Judge High Court of Tripura, to initiate this session.
A very good afternoon to all of you. First of all, I express our gratefulness to our Chief Justice for inviting a man like Professor Dr. Mohan Gopal to speak on the topic. I remember in the early days of our career, we had a feeling that only the High Courts and Supreme Court are the constitutional courts because they deal with writ matters and other constitutional matters. But in a class in the National Judicial Academy, Professor Dr. Mohan Gopal corrected us by saying that not only the Supreme Court and High Courts are constitutional courts, subject to correction, sir. Right from the Supreme Court to the court of the lowest rank, all courts are constitutional courts because in all courts we work to achieve the goals set out in our constitution. That is why the subject constitutional vision of justice is so relevant for us. You see, I don't know whether this practice is there in other high courts also. In our high court, apart from the high court judges, all judicial officers take oath. Immediately after their appointment, they take oath before they start functioning as a judicial officer. And the oath is that same oath which is taken by the High Court judges, that we shall bear true faith and allegiance to the Constitution. So unless we get ourselves familiar with the constitutional vision, with the core constitutional values of liberty, equality, fraternity, and dignity, how can we do justice to our oath? That's why we are so lucky that we have got Professor Dr. Mohan Gopal to speak on the subject, who believes that not in papers, Constitution lives in our mind and heart. Am I correct, sir? Yes. And see, just one or two lines. I have tried to understand the Constitution in my own way, from my own perspective. What I have understood is that our Constitution, it is said that we have made this Constitution by an agreement. We have given it to ourselves. It is a very compassionate document which takes motherly care of all of us. Like a mother takes extra care for the weakest of a child, it takes care of the most downtrodden, the common man. Probably that's why, sir, you were telling that the aim of the Constitution is to reach the common man. How? If you read Article 15(3), it makes special provision. It empowers the state to make special provision for the women and other disadvantaged children and other disadvantaged group of people. So what we shall request Dr. Mohan Gopal to tell us is how to follow this, how to implement these core values of liberty, fraternity, equality, and dignity of the individuals in our daily business in the district courts as members of the district judiciary. That is what we want to know from you. Of course, apart from other things, if you kindly emphasize on this aspect, then I think the judicial officers will be greatly benefited and they will be able to implement the constitutional vision of justice in their daily business. Thank you, sir.
Thank you very much, sir, for those very kind words. I also am very privileged to be here in this session with Honorable Justice Chattopadhyay, who I got to know many years ago, and I've learnt a lot from along with many judges. I've interacted with literally thousands of judges. I think I'm probably the person who's interacted with more judges than anyone in this country over now 15, 16 years, thousands of judges. And whatever I say is actually a reflection of what I've learned from judges. So I'm like a tape recorder. I record what judges tell me and then I play it back to you and others. And we've seen a very big change. I remember at the time that Honorable Justice Chattopadhyay was referring to, when I came to the National Judicial Academy in 2006 and started to organize sessions on constitutional vision of justice for munsifs and junior division, senior division, and ADJs and district judges. At that time, some Supreme Court judges asked me, why are you discussing this with subordinate court judges? And then we explained, and of course we also know that Chapter 6 of Part 6 of the Constitution is called subordinate court. So there is no nothing in the Constitution on Vice Chancellor, referring to both of us here. But there is a constitutional chapter, whole chapter on subordinate courts, not subordinate judges, subordinate courts. And so the subordinate courts are actually constitutional mechanisms. And it's very significant because in the 1935 Act, the section of the judiciary only consisted of federal courts and high courts. Federal court and high courts, the 1935 Act. There was no provision on the subordinate courts, because subordinate courts were part of the executive branch. They were not part of the judiciary. So the two innovations made on the judicial system in the 1950 Constitution was one, creating the Supreme Court, which did not exist until then, and second, giving constitutional status to the subordinate courts by putting subordinate courts into the Constitution. Yes, it is true that unlike High Courts and Supreme Court, the jurisdiction and powers of subordinate courts do not come from the Constitution. They come from statutes and under the statutes. But that does not alter the topic that we are discussing today, what is the idea of justice and what is the role of a judge. Because we are talking of the powers of courts. Now we are looking at what's the role of a judge who is presiding over a court. And I remember Justice R.V. Ravindran mantra coming to the Judicial Academy used to be that, talking even to junior division judges, you're a judge, I'm a judge. He was then a sitting Supreme Court judge. He used to say, you're a judge, I'm a judge. There are some things I can do that you cannot do. There are some things you can do that I cannot do. The only difference between us is jurisdiction, but we are all judges. And so we must understand the role of the judge. If after these 15 or 16 years, if there's one learning I've had after talking to thousands of judges about what is the biggest intellectual challenge facing the judiciary, on which the judiciary needs to build a consensus, I would say there are two, and they're related to each other. One is, what is the role of a judge? There is no consensus on that. And I think we need to develop a consensus on what is the role of a judge. And when I compare to some other countries where I've lived and worked and all that, there is much greater consensus on the role of the judge. And part of the reason is that all of you sitting here, judges of presiding over subordinate courts, are, I would argue, the most powerful judges in the entire sort of, common law, civil law world. Because nowhere else in the world do you combine the power to not supervise, but be informed about and order reinvestigation and further investigation. So nowhere else in the world does a judge have a court in the civil law, common law world, a role in investigation. That judge frames charges, judge then conducts a trial and finds facts, and judge also decides on guilt, and the judge also decides on punishment. In all these other countries, these are all given to independent agencies. Police does the investigation. Independent prosecutor who has the same status as a judge decides on who to charge and what charges to make. Facts are found by juries. Guilt is found by juries, and many cases punishment is given by juries. So what then is the role of the judge? All the 5 most important elements of a criminal trial are not done by a judge. So what then is the role of the judge? The role of the judge is to make sure that all of this is done in accordance with law, and then to instruct the jury on what the law is. So the judge becomes like an academic in those countries. I've been in those courts. My older daughter for the last 10 years is a federal prosecutor in the United States. She's prosecuting murder cases. And when I go visit, I go and sit in a court and watch her prosecute. And I hear the judges. The most important point is where the judge instructs the jury on what is the law. And so the judge is like an academic here. The judge must be a scholar of law, because the real role of the judge is to instruct all the parties on what the law is. So when the lawyers argue, prosecutor or defense, that this is the law, the judge will usually interrupt and say, please disregard that. I will tell you what the law is. Don't listen to either party. So, and my younger daughter is doing civil litigation also in the US. Similarly, the role of the judge is to really make sure that that's where the concept of rule of law comes in, to make sure the rule of law is maintained. Now, I wish he were here, but I heard Justice Sanjay Kaul, for whom we all have enormous personal respect and affection, as one of the scholars and one of the deeply insightful judges in the Supreme Court. And he said, and correctly, that he expressed a common belief that the role of a judge is really like a mediator. There are 2 parties, and you must settle the dispute. Now, I think that is where we have to start to reflect. Is that really the role of a judge in a democracy? This is such a complex issue that Justice Aaron Barak wrote a book called Judge in a Democracy. It's a very complex issue. If you read the 117th report of the Law Commission of India, chaired by Justice D.A. Desai, it's on judicial training. It is because of that report that we are sitting here today. Because he said in that report that the judiciary of India is facing an enormous challenge, especially the subordinate courts, to convert themselves overnight from being extension of the law and order machinery to being sentinels on the qui vive of fundamental rights. Qui vive means on the alert. So your role, according to Justice D.A. Desai, changed very fundamentally on independence. Overnight, he said. And he said, therefore, we need academies to be able to discuss and these changes and bring about these changes in the role of a judge. And I find that in our country there is still a hangover in a section of the judges in the trial courts, and also maybe in the high courts in the Supreme Court, that carries over from the 1935 Act, that somehow judiciary is part of, to quote Justice Desai, part of the law and order machinery. And the main concern of the judge is to ensure that order is maintained. Whereas he said that actually under the Constitution that role has changed. It is now as a sentinel, a guardian of liberty and freedom. And if you want to see the sharpest expression of that, you can see from a very experienced judge, who was by then a judge of the Supreme Court of his country for 37 years, Justice John Paul Stevens. He writes in a judgment, you can find it on the net, on Hamdan versus Rumsfeld. He says, look, I accept the case of the government that Hamdan, if he's let go or released, he will cause enormous harm, he will kill people, he will engage in terrorism. But he said, that's not my concern as a judge. My concern is to ensure that the law is maintained, that the executive does not, in seeking to punish Hamdan, the executive does not go beyond the boundaries of law. That's my role as a judge. If the consequence is that the law is deficient and he will go and do some harm, that's the problem of the law is deficient. But my job is to make sure that the executive stays within the boundaries of law. Right. So suddenly this role has changed very dramatically. We were talking 2-3 times about victim and accused. I think, what confuses me is there is no doubt that regardless of whether a suspect is identified, brought to trial as an accused, convicted or acquitted for the crime, the victim needs help. And in all countries in the world, investigation into the crime is separated from the issue of helping the victim. There's victim compensation fund that kicks in as soon as the crime occurs, totally unrelated to the investigation. The victim has undergone what I call, in most cases, a tsunami. The victim's life may be in tatters, may require all kinds of help. But that has nothing to do with the question of putting a human being, a citizen, or any other person on trial and deciding whether there is an adequate basis to punish that person for a crime. That should not be mixed up with the issue of the victim. Victim must get help separately from that. But the idea, if you read Oliver Wendell Holmes' Introduction to Common Law, small book, which is also available on the net, he traces the origins, the development of criminal law, where the transition came from individual revenge to collectivizing revenge, because people were all running around trying to get their own private revenge. So he said, no, let's collectivize this. And when you collectivize it, then actually it becomes, as Professor Faizan said, it becomes the responsibility of the state to handle the process of crime and punishment of the person who is suspected. So the idea that the conviction and punishment of an accused is somehow giving solace to the victim is an idea, I think, that has been abandoned a long time ago. Even as conservative a judge as Justice Katie Thomas, expert in criminal law, former member of the district judiciary, who became a very prominent judge, a jurist in the area of criminal law. Even Justice Katie Thomas has written saying that the idea of vengeance and retribution is no longer part of our policy, because we must act more rationally. It's very complicated, how much revenge, against who, for what, who else, and so it's very complicated. I'm not getting into that. So he said, this has nothing to do. Revenge has no place in criminal law punishment. So my question is, why are you linking in your own mind the question of victim suffering and the punishment of the accused? Unless you're thinking of giving comfort, psychological comfort to the accused, to the victim, saying that that person who did something against me has been harmed. And there you will find that human reactions are very different. If you go to the website, you may have if you go online on YouTube, you will find several such instances, but one of the most moving instances is of a Muslim person from Indonesia, whose son was delivering fast food. I mean, this Swiggy or Pizza Hut or something, and he was brutally murdered when he was doing this. And the murderer was caught, he was convicted. Then at the sentencing stage, not in the trial, they asked for the views of the families. Again, reflecting, they don't take that into account. They ask the families to make statements. So the father was called. And the father said to the court, it's on YouTube, you can see it. He said, look, I'm a Muslim. I believe in forgiveness. He said, I believe that only God has the right and responsibility to punish someone for their wrong deeds. And what God has taught me, the only obligation I have is to forgive. And then he turns around and tells this man, I forgive you. I forgive you. Then he said, I'm very concerned about your parents and about you. What will you do in jail? How much you will suffer in jail? How much your parents will suffer because you are in jail? And so his main concern was about the suffering of this murderer. And then he asked the judge, will you permit me to go and hug him? And the judge is in tears. The judge starts to cry and says, yes. Then he goes up and he hugs warmly this young man who killed his son, his only child. Now, that's another victim's reaction. So who are we to say, assume, there are victims who want revenge and punishment. But this man has taught us that the only way he will find solace is by forgiveness and not by retribution and anger. So we have many different approaches to this issue, and this is connected to the topic of justice because there is a very wonderful 182 words written by John Stuart Mill in his treatise on utilitarianism, on justice and morality. And in that, this is written in 1861, actually in the middle of the American Civil War, 1863. The American Civil War was between 61 and 65. And there he writes about what is justice. And he says, and in fact, Amartya Sen borrows his ideas actually. He says, look, very, very difficult to define justice because it means many things to many people. But let me try to define what is injustice. And then he identifies what is considered injustice, including attacking somebody, taking their property away, denying something that is due to that person. He says these are all instances of injustice. And therefore, he says, he argues that justice is actually and the difference between justice and morality comes from the fact that justice is a process where when something wrong happens, when some injustice occurs, people feel a sentiment of anger, resentment. And that starts with a small thing, like if I do something wrong, I'm sorry, I'm sitting without a jacket. I left my jacket behind in Delhi airport. I don't mean to be rude. So some people may think, okay, it's rude of him not to, we're all wearing jackets, why is he not wearing a jacket? Those things don't make you angry, but they make you a little not very happy. To the other end, where somebody kills somebody else, or somebody steals and robs from somebody else, and people get very angry. And they want very severe punishment because they want a strong message to be sent that this is not acceptable behavior. And they want, they want to express their anger. And John Stuart Mill argues that in this spectrum of reaction, there are some kinds of conduct, wrong conducts, which are so extreme that the anger is very, very high, the maximum anger. And he says justice is really, according to him, the reference to those kinds of the moral qualities required to prevent those kinds of bad actions which are extreme, and the following of which are required necessary. So you tell people don't murder, don't kill, right? So it is injustice to kill. So just to be justice, not to kill. Why? Because killing creates this extreme emotion and anger. But this was over 100 years ago, nearly 150, more than 150 years ago. And we have moved on from that. And we today have to reflect on the question of what is justice and how do we secure it? How do we secure it? So initially there was this idea linking an immoral act, an act that violates morality, and then understanding that there's a range of public reactions to it, taking the actions which draw the strongest reaction, attaching it to it the highest consequences, and then saying the moral values which are offended by such actions are what we call justice, and linking that to the anger and sentiment of people. In fact, Mill argues that justice is basically a feeling. It's a feeling about what is important, what are the values that are most important to society. But the question is, today, what do we understand as justice, and and is there a difference to the theory of justice brought about by the Constitution of India? That's a sharp question I want to focus on today. What is the meaning, and does it have a different meaning after the Constitution of India was enacted? The focus of my work has always been on how changing theory changes practice. And one example I will give is, when I went to the National Judicial Academy, I knew that the theory of the Judicial Academy was training judges. And I had association with the Academy from the year 2000 when I was in Bangalore, and I had gone to Karnataka Judicial Academy, and I'd seen how judges would come and just read prepared text and leave with no interaction at all. So I said, look, this is because they were being trained. So when I went to the Judicial Academy, I changed the theory of judicial education. I said, judicial education is about conversation, reflection, by judges with each other, and by judges with citizens and stakeholders of, justice is a public good for all of us, not just for judges. You are in charge of securing and safeguarding the most important public good for us. So judicial education must be a conversation. And this changing of the theory of what is judicial education, I think, gave a lot of life to the whole enterprise of judicial education. Judges became very enthusiastic because they were not coming to learn or to teach or to be trained, but really to discuss, like we are discussing now, in a broad range, open mind, the very difficult questions that they deal with. And across the country now, judicial education has changed. There are other examples I can give you also about how changing theory actually changes practice. So I believe that we must change our understanding of the theory of justice under the Indian Constitution. That will change the practice of courts in our country. And so let me start with the permission of the Honorable Chief Justice, who I must acknowledge as one of the pillars of national judicial education in our country, because he has spent, at my humble request, untold hours in the National Judicial Academy, interacting with and having conversations with, and when I see him, my mind goes back to those conversations with thousands of judges at the National Judicial Academy who he has deeply influenced, because he was always there. It was very quiet. He was very calm. He spoke very profoundly and with great respect. And judges just soaked up what he was saying. So I feel a little embarrassed to talk in front of him because he knows all this more than I do. So it's an honor, sir, to be here in your presence, Chief Justice. So the question, with your permission, sir, I may ask a question and let one or two responses come. What do you think is the idea of justice under the Indian Constitution, and how different is it from justice as of before that, as during the colonial period or during the feudal period? Anyone? What do you understand as justice? You are implementing the Constitution as the judges of our country, doing a wonderful job. What is your understanding? You see, Article 39A gives a mandate to the entire legal system to promote justice. The preamble to the Constitution says that we, the people, having solemnly resolved to constitute India into a sovereign, socialist, secular democracy, have enacted and given to ourselves this Constitution for securing justice as the first objective. So what do you understand as justice? Again, as the Honorable Chief Justice said, I'm not looking for right or wrong answers, just for a conversation. And in fact, I learned from. Yes, sir. Yes, sir.
Sir, in simple words, what I understand, justice is the protection of rights and liberties of a person, and we may say also to give one's due. In our constitution, so far I understand, in two places the word justice is used. One in our preamble and under Article 142.
And 139A also.
Two or three
Yes.
places only. In preamble, the main thing is justice.
Not 39A, sorry.
39A,
Yeah.
so legal aid,
Yeah.
regarding legal aid provision. But basically it was in 142 and in preamble.
Yes.
Justice, social, political and economic. So this is, I think this is a part of distributive justice which we can't do as trial judges.
Yes.
And so far 142 is concerned, that is complete justice in accordance with law.
Yes.
So this is my idea.
Yes. But what do you understand as you say it is protection of rights of people and giving people their due, right?
Yes.
Okay, very good. Thanks. Thank you, ma'am, for that.
Good evening, sir.
Yes, sir.
Hello.
Yes, sir.
As far as I understand,
Yes.
the concept of justice is
Yes.
to administer the law as
Yes.
per situation.
Yes.
Supposed to apply the law in a given situation in a way that the rights of both the accused and the victim is kept
Yes.
intact.
Yes.
Thank you, sir.
Thank you. Very again, very good point and very important point. So, for example, that would go along with Justice Call's point that the job of the judge is to make sure that everybody's interests are protected and a fair resolution is brought to the dispute. Yes, ma'am. Yes, sir. Sir, when should we finish, sir? Sir, what time should we stop, sir? What time should we stop, sir? This 4:45. Yes, sir. Yes.
To me, justice is to give one his rights, whatever he has,
Yes.
according to the established norms, principles,
Yes.
and ensuring that he get access to all the rights, procedural rights.
Yes. Yes.
This is the main thing.
Yes. Okay. So, in other words, justice is an administrative mechanism to ensure that the state will protect people's rights, give people what they are due. So it is really an administrative intervention. Whether it is by the courts or by collector or anyone, by the state, it's a state instrument, right? Is basically what you're saying. Yes, sir.
Justice may mean the judge to give judge decision
Yes, sir.
in consonance with the constitutional fabric.
Yes, sir. So again, it is a quality of state decision making.
Yes.
It is a quality of complying with procedure, certain quality of state decision making.
Fair decision.
Yes, sir. So do you think, sir, then, please sit down, sir. Do you think that we fought a freedom struggle and enacted the Constitution and made the first objective of the Republic only for this purpose? To ensure that the state will have an instrument to protect people's rights and that they will act accordingly? Is that important enough to put as the first goal of the entire Republic? So what you're saying is 100% right. If you read John Stuart Mill, he reflects these views. What you're saying is accepted view. But has that view been changed? Has that theory been changed by the Constitution is my question. What you're saying is correct. But is it correct under the Constitution is my question. How do we understand the word justice, social, economic and political? Is it simply state action? Now let me, for lack of time, respond to that by saying there's a wonderful judgment written by Justice Ravindra Bhatt, February 2020. The name of the case is Prithviraj Chauhan. It's about SCST atrocities, but he has and I wish Professor Faizan was here, because he has a very different take on what the Constitution is. He says people say it's an administrative document, contract and all that. Yeah, sure that it is. But he says no, he I think drawing from some of the discussions, I would like to think, amongst judges, that he's had with judges inside our academy, the Delhi Judicial Academy and so on, he comes up with a very remarkable definition of the Constitution of India. He says, the Constitution is a compact, an agreement. So that's what Professor Faizan also said, it's a social contract. But he said it's a compact between people, on how they will treat each other. In the society, which was full of hierarchy, is full of hierarchy and differences. So Constitution is a compact between the people on how people will treat each other, the values by which they will treat each other. This is what the Supreme Court is saying now. That's a remarkable definition of a constitution. So we the people have decided to constitute India into a republic and to secure to ourselves justice. Now then, in that context, what is justice? The word justice can best be understood by the first three alphabets, J-U-S. I've talked a lot about it in various forums, but does anyone know what J-U-S means? It's probably the single most important word for a judge because it is the root of the word judge. J-U-S. J-U-S plus D-E-C-I-R-E is the root of the word judge. J-U-S pronounced as use, means the right value, the right value. The legal system is concerned only with one issue, entire legal system. Is human conduct right or wrong? And if it's wrong, what are the consequences? If this thing falls on my head, I cannot go to a court unless I can point out there was a human failure. I can only go to a court against another human being. I can't go to the court and say that, a tree branch fell on my head because the wind was too high. The court will say we have nothing to do with it. A court is only a forum to decide an issue of whether human conduct is right or wrong. Now, if that is correct, then you can only decide that against a standard, a benchmark. Is it right or wrong? That benchmark you can draw from the law, or you can draw from established authorities like scholars and so on and so forth, or you can draw it from your own heart, your own conscience, your own background, your own training. That's not the right thing to do, but it's almost unavoidable that we will draw on what our own personal sense of right or wrong is. And when you look at simply law, again, I'm going to say something which is very simple, which you may not immediately, it may not be clear to you, it may seem confusing. But a law, Indian Penal Code, I don't have it here, is simply a set of hypothetical facts. It's just a set of rules. It sets out a hypothetical fact pattern. If with intent to cause death, you do an act which actually causes death, then you committed murder, right? That's a hypothetical fact pattern. And what a court does is to see whether the actual facts match this hypothetical fact pattern or not. And if it matches, then the liability follows. If it doesn't match, then there is no liability, right? So a law cannot tell you very much about what is the benchmark of deciding what is right or wrong. It is like if I want a child I tell a child act safely, I also tell the child a rule, don't put your finger in boiling water. That's a rule. But the norm, the standard is you must act safely. So if he comes and says, I put my hand in oil, boiling oil, but you only told me to put in water, that you didn't prohibit that, then I can interpret don't put it in water and saying that also covers oil, because the the standard of conduct I'm trying to impose on you is that you must act in a safe manner. So we cannot get the benchmark for deciding whether human conduct is right or wrong simply looking at the hypothetical fact pattern. That's a law. We must also understand what is the standard of conduct, the moral rule. Remember, morality, according to Mill, is just the softer version of what becomes law and justice. So it's in a spectrum. All of this concerns people's ideas of right and wrong. Some of then there's a lot of politics behind it. Some of it gets converted into harder versions of you shall not do it, converted into law and then punished. But all of these are a spectrum of what is right and wrong conduct, right? And therefore, we have to look at the law and understand what is that right conduct that it is trying to uphold. Remember, Mill said that the most important right conduct you have to uphold is what is justice. Because if you offend that, people get so angry and they consider it injustice, and therefore they will give you the highest punishment. Therefore, justice is really the most important standard of conduct, right? So, therefore, to understand the rule of law, we have to have a benchmark to decide whether conduct is right or wrong, and that benchmark has to be some value of human behavior, mulya, not just a rule. It has to be a mulya of right conduct, right? And that mulya, where do you find it? So we could find it earlier in our traditions, religion, family, or in our own personal view, but I would argue now you have to find that mulya in the Constitution and nowhere else. Nowhere else. That is what will ensure that all of the legal system will at least refer back to the same set of values across this country, whether you're in a court in Kanyakumari or in Kashmir or Gujarat or Assam. We must be sure that the Sanhita that a judge will look at to decide whether conduct is right or wrong, the benchmark must be found in the Constitution. The judge must be able to explain, I have used this benchmark, I'm guided by this benchmark to decide whether human conduct was right or wrong, and to interpret the law, because it comes, and this is why I think it comes from the Constitution. It need not be explicitly in the Constitution. You can make an argument that is imaginative and find new meaning in the Constitution, but it has to come from the Constitution. So if use means right value, justice actually means the crystallization of those values in actual human conduct. That's what justice means. And that is the meaning of the Latin word, justitium. So use is the right value that should govern human conduct. When human conduct follows the right conduct, that once it is crystallized, that condition in which right conduct is followed, we call that justice. That's why we say justice prevailed. People behaved in the right way, or were made to behave in the right way. Or injustice prevailed because the right conduct was not followed. Or justice was secured, or justice was delivered. Means what? You ensured that human conduct follows the right. You ensured the crystallization of those values in actual human conduct. Therefore, now we understand that justice actually means justice refers to a standard of human conduct, the crystallization of a standard of human conduct, That's what justice refers to. So therefore, when the preamble says justice, social, economic, and political, the preamble means that in this, we want a republic where in all our activities, economic, social, and political, right conduct shall prevail. The right value shall be followed in all aspects of our conduct, private, public. That's why there is one more reference to justice, which I'm sure you remember, and that is in Article 38(1). Article 38(1). The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order, not economic or political order, a social order in which justice, social, economic, and political, shall inform all institutions of national life. Institutional economists like Douglas North define an institution as a set of rules and the way they are enforced. So, family is an institution, not formal rules, informal rules, customs are all included. So the Constitution says in 38(1), all institutions of national life, families, communities, all institutions of national life must be informed by right values of the Constitution. That is why we created this republic. Now we come quickly to the question of what are the right values in the Constitution? That's why, sir, I was saying that all courts, including junior division, senior division, ADJ, DJ, all of us as individuals, as teachers, as private citizens, we are all responsible to ensure that in our own conduct and in the conduct of others, the values, right values in the Constitution are crystallized and followed. Now, what are those values? You'll find those values mainly in the preamble. And there are, once Professor Bakshi very eloquently said, the Constitution is the preamble, the rest is a footnote, he said. And if you look at the preamble, you'll find these values. I would count about 12 values in the preamble, but leave aside, let's look at socialism, let's look at secularism, let's look at democracy. Democracy comes from two words, demos and kratos. Kratos means power, demos means common people. So democracy means power is held by common people. So socialism, secularism, democracy, liberty, equality, fraternity, all of these are about how people treat each other. If my freedom is taken away because a boulder has fallen in front of my house, I won't say I've lost my liberty. I'll say I'm trapped. But if a group of people, Gundas, come and say, you shall not get out of this house, I'll say I've lost my liberty. So socialism is about how people treat each other in a social way. That's why we say he's a social fellow, this fellow is antisocial. Social comes from the Latin word socius, it means friend. Social means friendly. Socialism means, like fraternity, it's a friendly society where people care for each other. That's the vision of the Constitution. Create a friendly society where people care for each other and look out for each other. So socialism is about how we treat each other. Secularism is about how we treat each other. Panth nirapeksh, that we treat everyone with love and affection and respect. Panth nirapeksh. That's the Hindi official text of the Constitution. Does not say Sarva Dharma Samabhava. It says Panth Nirapeksh. So these, similarly equality. Equality is about how we treat each other. Human beings. Fraternity is about how we treat each other. So we now understand that justice has now become under the Constitution not about how institutions deliver, protect others in a kind of Mai-Bap way. Superior institutions protecting people, or whether you follow the law in making your judgments. No. Under the Indian Constitution, the theory of justice is a standard of human conduct on how we treat each other. And you marry that idea with the Supreme Court's own very recent, 1 year ago, interpretation of the Constitution as a compact between the people of India on how we shall treat each other, and then you get the complete picture. That we are dealing here with an idea of justice that may be unprecedented in the world. It's a commitment. Why? Because in our country, we have had a huge crisis about how we treat each other. In my state in Kerala, probably the worst in the country, there was not only untouchability, there was unseeability. Unseeability. That some people cannot appear during sunlight. They can only come after dark, so that no one will see them. And if they're seen, they're liable to be physically punished and subject to corporal punishment and imprisonment and so on. So we had a crisis on how we treat each other. And therefore we must understand justice as a concept about how we cure that. Because again, going back to that little piece by John Stuart Mill, he says, and I'm quoting him, the entire history of social improvement, is a series of transitions by which a custom or institution which was once considered to be a primary necessity of social existence is passed into the rank of a stigmatized injustice and tyranny. So we take the way women are treated. At one point, this society, many societies accepted that as a necessity of social existence. But today, we are passing it and reconceptualizing it as tyranny and injustice. So what you have to do with your judgment, and this is where I come to the point, I wish Justice Kaul was here, that the real job of a judge is to safeguard the constitutional standard of human conduct in every case and stigmatize, give a negative understanding to those practices and social customs that are inconsistent with these values of equality, liberty, fraternity, socialism, as Honorable Justice also said. These values have to be stigmatized. Anything opposed to them must be stigmatized and said that's wrong, that is tyranny, that is injustice. So when you make a judgment, a decision, even as a junior division judge, what you're deciding is human conduct right or wrong? So let's say there is a slum, lots of houses, and every night that slum people there can't go to sleep because there is a man who comes drunk and beats up his wife, and the wife is crying with pain, and the children are crying, and no one else can sleep because they are all tightly packed together. But let's say one day there is silence. The beating stops. And everyone asks, why is there silence? Why did the beating stop? And then somebody says a judge used a law to get this guy to stop beating her in an instance of domestic violence. Through that action of yours, that decision of yours, you would have sent a signal to the whole of society about what is right conduct and what is wrong conduct. You are not settling a dispute. You are deciding there is a dispute. What is the real... Yes, you are settling a dispute, but what is the dispute you are settling? The dispute you are settling is what is right conduct and what is wrong conduct. I've had people in Delhi, I also live in Delhi part of the time in Kerala, tell me old Haryanvi, I think, or Hindi saying, which says, it is better to beat your neighbor's, your wife than your neighbor's buffalo. This is what Mill says was once accepted as a social necessity. Beat your wife, but don't beat the neighbor's buffalo. We want to say that standard of conduct has now changed. And when you intervene and in one night, because of one order you make under the Protection of Women Against Domestic Violence Act, that beating stops and there is silence in that slum, that silence speaks a million words. And people understand that it is not right to beat your wife. And therefore, we are giving justice a new meaning as the right standard of human conduct. And your job is to, as I see the job of a judge, I shouldn't say your, it's disrespectful, the job of a judge, highly venerable and respectful institution, very central institution for this reason, is to authoritatively declare what is constitutionally right conduct and what is constitutionally wrong conduct. Because the constitutional vision of justice meaning right conduct, is liberty, equality, fraternity, dignity, is at the core of the constitutional vision of justice, because justice is a standard of right conduct. And to bring this to life in an uncompromising way, without balancing those values against anything. Not giving, that's why recently again, Justice Ravindra Bhatt has written another wonderful judgment 3 or 4 or 5 days ago on this overturning a Madhya Pradesh High Court judgment where a person, a victim of sexual assault was asked to tie a rakhi on the hand of the person who committed the assault. But please read that judgment. It is bringing to life this new theory of justice of the Constitution. That theory of justice of the Constitution is about how human beings treat each other. Because the Supreme Court says the Constitution is about how people should treat each other. That's a new theory of the Constitution. And that's like doctors, medical doctors are guardians of health. You are guardians of constitutional conduct, constitutional values. People should tremble thinking of you if they think that they will take away somebody's liberty, somebody's equality, somebody's fraternity because you will stop them. Somebody's dignity. I can tell you a wonderful example. Justice Qureshi was one of the resource persons in that program. Young, sir, you may or may not recall, number of young, you would definitely recall that very large number of young junior division officers came for national orientation program at the same time, and it was a wonderful program, and you've come and guided that many times. Some of them were from Tamil Nadu. And the then director of the Tamil Nadu Judicial Academy, who is now a High Court judge in Tamil Nadu, told me that the newspapers reported that one of the junior division judges who went back, this got huge positive attention in Tamil Nadu. He saw that some suspects were accused were being produced before him without their shirt on, only with the dhoti, just to humiliate them, as the police often do. You know, they were handcuffed and brought there, and then handcuffs were removed. They were brought into the court without their shirts. This young magistrate got up from his chair, and he said to the police and the prosecutor, "You put on shirts for them and protect their dignity. If not, I'm not going to hear this case." And he went into his chamber and he said, don't want you to take shirts off somebody else and put it on them. I want you to buy new shirts for them, and I want to see the bill, you know, because I have to protect their dignity. And the amount of appreciation that this got was incredible, because the police, senior police officers told the director of the Judicial Academy that this has sent a big salutary message to the police that if you attack the dignity of an ordinary person, then the judges are going to crack down on you. So suddenly we are seeing this new theory of justice as constitutional, as the constitutional conduct, right, by people. And the role of the judge as protecting constitutional conduct, and the Constitution as a compact on how we will treat each other, because this is the great. I mean, I've lived in 3 other countries other than my own, which is India, but I can tell you, we will never. Yes, we can build big buildings and all that, but we will never be able to substantially move to a situation where we don't have mass poverty in this country unless we learn to treat each other differently from our hearts. We must see everyone, regardless of caste, class, gender, region, as people with equal freedom, equal dignity, and equal potential. If Stephen Hawking had been born in Bihar, Madhya Pradesh, Uttar Pradesh, even in Kerala, as a paraplegic, he would have died in some gutter in Trivandrum. Who would have known that in that paraplegic body lay the mind of one of the world's great physicists? Who knows what lies, actually what gems and diamonds lie in the mind of all those people who are now treated in that manner. So let me stop here so that we can have a little discussion. We have got about almost 15 minutes left to 4:45. We are at 4:32. 4:33. So the main point I want to submit to you is that we have to rethink the idea of what is justice. Let me also just say this in conclusion. We know as a matter of fact that there is no general consensus on what justice means. When you have studied in your LLB classes, if you have studied jurisprudence, you know that there are at least 10 or 12 definitions of justice. And we are aware of that. We know that, Rawls has a definition, Dworkin has a definition, and Kant has a definition, Mill has a definition. What does this mean? That there is no one really knows what justice is. Therefore, I argue that we need to do two things. One is we must see, for the others, for the philosophers, for the sociologists, economists, justice is not a central idea. They can do their work even if they don't have a clear idea on justice, which is why they don't have a clear idea on justice. It's not important to them. They have a clear idea on what is the normal temperature, 98.4, because they can't do their work without that. But justice, they don't have an idea. But for us in the legal system, we must know what is justice. Because we have an obligation. I don't see 39A as a legal aid provision. I see it as a promote justice provision, therefore legal aid. Article 39A says the legal system shall ensure that the state shall ensure that the operation of the legal system promotes justice on the basis of equal opportunity. That is a substantive part of 39A. That's a mission of the entire legal system. Therefore, legal aid must be provided, because that is our... Sorry, sir? Access to justice, yes. Sir, actually, it defines a mission of the legal system, 39A. Yes, sir. It tells us the legal system must promote justice. Two beautiful words, promote justice. Now, we know that we have that obligation. We have 38(1), we have 142, we have preamble. So as lawyers, and we have many honorable judges here who carry the word justice in front of their name for life. We still refer to Justice Krishna here. Now, when I ask them, what is justice, and they tell me, can't be defined, then I say, why do you carry a word in front of your name that you can't define? Can be defined. But it cannot be defined generally, because these guys have not done a good job. The philosophers and the political scientists have failed to do that. But I feel, therefore, first point I want to make is we must have a legal concept of the theory of justice, a legal theory of justice for us, because we need it. We need it. And you have yourself given the earlier legal concepts of justice, administration of justice, protecting people's rights, giving them what they're doing, what is due to them. I am now suggesting that the Constitution of India has altered the legal theory of justice, and that the legal theory of justice under the Constitution of India is justice is right conduct, constitutionally right conduct. That is justice. It is only when people behave in the right way according to constitutional values that there is justice. If not, there is no justice. You can get all your judgments right, you can get all the paragraph numbering right, you can refer to all the precedents, do everything perfectly. But if at the end of the day you don't protect and uphold constitutionally right conduct, then it is like saying operation successful, patient dead. So this is the conceptualization of justice that I would like to place for your consideration. I'm only an academic, I'm just a private person. What I say can be torn up and thrown into the waste paper basket, or you can reflect on it, and that is the beauty of my role. I can say what I want, knowing that none of you are obliged to accept it. So let's have a few questions, and then end. With your permission, sir.
We must say that having Professor Dr. Mohan Gopal physically present before us is a rare opportunity. So if you have any doubts, we have only 6-7 minutes in hand. Please. Any question? Any question from this side? Probably they are all eager
Some
to
loose contact. Any questions or comments? If not, let me just end with a practical problem on how to secure justice that I mentioned to Chief Justice also. It's a practical problem in Kerala, which some people brought to my attention. There is Kerala's tallest, foremost scheduled caste social reformer from the early 20th century is a person called Mahatma Ayyankali. He's called Mahatma because he was a friend of Mahatma Gandhi, and Mahatma Gandhi actually went and visited him. He did incredible work in Kerala for reforming the scheduled caste community. There's a small little building, which is he came from a very poor background. He's got, where he was born is all gone. There's a small little building where he used to live and work, which some interested, motivated forces 2 days ago attacked. They took out the tiles under the guise of repairing it. They took out the tiles, but the workers said they've been instructed to demolish it. So, and the government is in the process of declaring it a protected building. So they wanted to do it before that, and they wanted to commercially or reconvert that use for some other purpose. The question is, what can I do? I live in Trivandrum, where there is no high court. So I contacted 2 or 3 of the lawyers, very senior, very experienced lawyers, and said, can I file a petition under Section 9 of CPC? Not I, because I have no personal stake in it. I'm not involved in any way in it. I just came to know about it. But can one of the affected people, members of the community, who are part of Ayyankali's community, can they file a petition under Section 9 asking for relief under Section 91, which speaks not only of public nuisance, but also of wrongful acts which adversely affect the public? And the reaction I got was very negative. They said, sir, adversely affecting the public means blocking the drain, blocking the road. But I said, look, this is destroying a historic monument in which future generations of students have vital interest to visit. It's a museum. You're affecting the education of future people. You're affecting the knowledge of current people. If this is not public of interest to the public, I don't know what is. But they are, so I was telling the Chief Justice also, the problem is not only the judges, the lawyers are not willing to imagine the law, Section 91, in a new way, because their theory of justice is wrong. If they had understood justice as a way of how we treat each other, then they would have said, look, this is not the way to behave. This is against the constitutional values of dignity, attacking fraternity, attacking dignity. And therefore, we have to uphold this action which is antisocial. And that is what actually Section 91 is meant to actually address, antisocial actions. So now we should link Section 91 with fraternity. And anything that violates the constitutional value of fraternity should be seen as violating 91. But the bar is not willing to do it. I have a feeling that if the bar actually brings a petition, the judges who have been participating in Judicial Academy discussions will be much more receptive to this than others. So, but this is a small example. If you were the judge there, in this case, filed before a munsif under Section 9, based on Section 91, asking for an injunction that this building's demolition should be stopped because it is, and ask the government to report on what is the progress in declaring it a protected monument and what is going on. Meanwhile, keep the status quo, don't demolish it till a decision is taken on how this monument is to be protected. This is an example of how, at your level, as you were asking me to give you an example, sir, I was thinking of that. This is an example of how even a munsif can play a historic role in understanding and interpreting and protecting constitutional rights in a very meaningful way. The people who talked to me said, sir, what will we tell our future generations that in our time this last monument of Ayyankali got demolished? And they have nothing left to see, nothing left to come and educate themselves. So I had no answer to that. So I wonder if any of you would like to put yourself in the shoe of this hypothetical Kerala Munsif who has not received such a petition. And I'm saying this because I never discuss an actual case, but this is very far away from you, so I can take the liberty. Any reactions? How would you read 91? Would you see this as involving a issue of protecting constitutional justice as I have redefined it? Sir? Yes, sir. Yes.
As you have said, in my understanding,
Yes, sir.
civil laws are much more extended, much more wider
yes,
than the criminal laws.
Yes.
So I have not considered Section 91 of CPC as you have pointed out today.
Yes.
But there is certainly a horizon we
Yes.
can think of.
Yes.
And these provisions are not to be interpreted in the manner we have been interpreting those
Yes.
earlier. But
Yes.
if it is the requirement of justice, this should have been interpreted,
Yes.
should be interpreted in wider sense in future, so that our constitutional vision of justice is protected
Yes.
and secure.
I think the young judge deserves a round of applause for that very positive, very positive response, because that's all we want, that you have a positive approach, understanding that today the battle of justice is the battle of establishing a new standard about how we treat each other as people in this country. That is how we must understand justice, as a standard of constitutional conduct. Okay, it's exactly 4:45, sir.
Thank you, sir, for your valuable words, enlightening on the role of judges, that is to make sure everything is in the process of rule of law, and that the rule of law is maintained, and that the executive does not go beyond the boundaries of law. And in mentioning the Prithviraj Chauhan's case, which is held that constitution is a compact between people, how they treat each other in a society. Thank you, sir. With this, we come to the end of today's program. Thank you one and all who have gathered here and made your presence in the program. All participants and dignitaries will have sufficient time to go back to their rooms, freshen up, and join us at the High Court at 5:45 p.m. for an exciting evening of entertainment filled with cultural program, followed by delicious dinner. Honorable Governor of the State of Tripura is going to come, so it's requested please be on time. Thank you.